If you are attending an SSDI hearing, one important part of the process involves something called the Medical-Vocational Guidelines, also known as the GRID rules. These guidelines are frequently used by administrative law judges, or ALJs, to help determine whether a person qualifies for disability benefits. The Medical Vocational Guidelines are designed to evaluate whether someone can realistically adjust to other work despite their medical condition and limitations. Instead of looking at just your diagnosis alone, the SSA looks at a combination of factors that affect employability. The ALJ will typically consider your age, education level, work experience, transferable skills, and your residual functional capacity, often called RFC. Your RFC describes what activities you can still perform despite your condition, such as how long you can sit, stand, walk, lift, focus, or interact with others. Age can become especially important in SSDI cases. Under SSA rules, individuals over 50 may be treated differently because the agency recognizes that transitioning into new work can become more difficult later in life. Someone with a history of physically demanding work, limited education, or non-transferable skills may qualify under the GRID rules even if they are not completely bedridden. At hearings, ALJs often ask vocational experts hypothetical questions about different work limitations. For example, the judge may ask whether a person who can only stand for short periods or frequently misses work due to medical symptoms could still maintain competitive employment. The answers to those questions can strongly influence the final decision. The medical vocational guidelines are not always straightforward. Two people with similar medical conditions can receive different outcomes depending on their age, prior jobs, education, and documented limitations. That is why consistency between medical records, physician opinions, and work history is so important during the hearing process. Disability Advocates Group helps individuals prepare for SSDI hearings by reviewing medical records, identifying vocational issues, organizing supporting evidence, and helping ensure that work history and functional limitations are clearly presented before the hearing. If you are applying for SSDI or appealing a denial, call Disability Advocates Group at 800-788-2095 for a free consultation or use the free SSDI screener on our website to see if you may qualify. Disclaimer: this video provides general information about SSDI. It does not constitute legal advice.